Okay, everyone, new filings in Don Lemon's criminal case. First filing. The attorneys for Georgia Fort, she's a co-defendant who claims she was just at City's church as a journalist and didn't participate in the intimidation and bullying of churchgoers. Georgia Fort's attorneys just filed a motion for immediate disclosure of Brady materials and for a status hearing. Now, the defense attorneys say that discovery material indicates that the government at one time accused Georgia Fort of participating in the bullying and harassment of churchgoers, although she did not participate in those acts, according to her defense attorneys. And that, based on how her defense attorneys characterized the discovery material, the indictment against Georgia Fort must be dismissed immediately, they say. It's bizarre. The assertions by Georgia Fort's defense attorneys have to be tested at trial unless the prosecution agrees that there's no evidence that Georgia Fort was part of a conspiracy and moves to dismiss her before the trial. Now, the prosecution could decide to do that, but here the defense attorneys are saying the charges must be dismissed before trial. Tell it to the jury. Apparently, the prosecution doesn't agree with how the defense characterizes the actions of Georgia Fort. So now the defense is asking for a status hearing to try to convince the judge to tell the prosecution to dismiss the indictment against Georgia Fort before trial for alleged lack of evidence. I guess the defense doesn't want to go to trial. The discovery material apparently says that defendant Fort used her camera as an instrument of intimidation. Now, in my estimation, that's a classic setup for a takedown at trial, and Georgia Fort won't be testifying on Fifth Amendment grounds. So, unless I'm mistaken, the government witness will testify that the defendant used her camera as an instrument of intimidation or words to that effect. The defense will try to impeach that witness, and the government will rehabilitate the witness using footage that shows the camera being used to intimidate, or maybe Georgia Fort's comments on her YouTube channel will be shown, in which she supports anti-ICE activism and doesn't just act as a neutral observer. In fact, all of the journalist defendants have an uphill battle because they're on social media even now expressing support for anti-ICE activism, especially Don Lemon. The I'm just a journalist defendants can be impeached by their own most recent narratives on social media and by their own behavior, which wasn't characterized by professional distance. Now, on to the Brady issue. The prosecution's discovery obligations require turning over to the defense any items that are exonerating or favorable to the defense. Now, here, the discovery items that Georgia Fort's attorneys obtained apparently assert that she participated in the chanting that took place during the church attack. The prosecution didn't indict her for chanting, however. The indictment and superseding indictment contain no allegations that Georgia Fort participated in chanting "ICE out," "hands up, don't shoot," and "stand up, fight back." And yet, her defense attorneys say the grand jury transcript, which they have not seen, must be classic Brady material because the prosecution could have told the grand jury that Georgia Fort participated in the chanting, despite not indicting her for it. No explanation in the defense motion why that would be. So, what are we talking about here? It's unindicted alleged conduct. Now, the defense attorneys say, in referencing alleged source material that we don't have access to, the defense attorneys say that the government investigated Georgia Fort for chanting "ICE out," etc., but didn't indict her for it. Now, Brady items need only be turned over to the defense if they meet the standard of materiality, which is a reasonable probability that the evidence would have affected the outcome of the trial. Now here, the defense motion contains no indication why discovery items about the alleged unindicted conduct must be turned over under Brady or Giglio, because typically, investigative material need not be handed over as part of discovery. So what are possible reasons why the material should be handed over? The defense says that there's not a single witness who will testify that Georgia Fort participated in chanting "ICE out," etc. Now, they can't possibly know that, but that's what they say. And they refer to investigative material in which a government agent apparently said that Georgia Fort did participate in chanting "ICE out," etc. Now, again, she wasn't indicted for chanting, she was indicted for conspiracy. But the defense says the alleged discrepancy there indicates that the government witness investigating the case was in error, and so it impeaches the credibility of that government witness. However, that government witness hasn't testified at trial yet because we haven't gotten to the trial. Now, the Jencks Act requires that prior statements of the government's witnesses have to be turned over after they testify at trial. So, the Jencks Act leaves room for the real issue here, which is investigation of conduct that's ultimately not indicted. Now, in this case, the government says it will produce Jencks Act statements 28 days before the trial. So, if the statements aren't handed over by then, it would indicate that those government witnesses will not testify. Now, Georgia Fort's defense attorneys aren't making a lot of sense here. They seem to be asserting that the government cannot even investigate conduct unless it ends up in the indictment ultimately. And a new filing this week by the government, which sought the court's authorization to voluntarily release a transcript of grand jury testimony and materials relating to one witness whose testimony contradicted the government's official narrative of what happened at City's Church. So that's classic Brady material, and the government is fulfilling its obligation to disclose it. The court immediately granted the government's request for release of that material, and we may get access to that material as well before trial, only if it's disclosed on the public record. So, in any event, I'll be reporting on that issue. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.